3, 2, 1, start. Sections 3 and 10, Rule 8 of the Rules. Punishment for unfair means at the examination, candidate expelled from the examination. When found cheating, fine imposed under the Act deposited by the candidate. The High Court, at this stage, should not intervene in the matter until it is considered by the Unfair Means Committee, and the examination board has also the VC of the university, who are the competent authorities in terms of the rules for the guidance of the examinees, as also for granting punishment for unfair means at the examination. Writ application dismissed. Full stop. Section 10, Sections 35 and 4. Scope of revision is circumscribed to an extent in order to quash and set aside the concurrent findings of fact recorded by two revenue courts. There ought to be a case of illegality, perversity, or serious prejudice, or non-examination of the documents. Merely because the decree of the partition suit in appeal stands abated does not mean that it cannot be carried further when civil court decreed the suit in respect of the partition of the properties between the petitioner and other heirs, same ought to have been considered in right perspective decree in a suit for partition of property, or separate decision assailed therein will not be included and covered by Section 4 of the Act. Full stop. Sections 10 and 35, authorities under the Consolidation Act, being judicial authorities, have to pass judicial orders, but not in perfunctory manner. They have to record reasons. Full stop. Section 10 and 35, reversing of concurrent findings of facts recorded by two authorities, assigning reasons. It is incumbent upon the revisional court or the revisional authority to assign clear and convincing reasons for setting aside concurrent findings of facts. Object of Section 35 is to empower the Director, Consolidation to see that subordinate courts are not acting arbitrarily and illegally in the exercise of their jurisdiction. Scope in the revision is limited, unlike the appellate authority, which can reappreciate and re-examine the finding of facts. Inferences or surmises would not satisfy and would not be legal to quash concurrent finding of facts. It is incumbent upon the revisional authority to deal with and show in impugned order as to how and why findings of facts are sought to be reversed. Full stop. Sections 10b and 35. Section 10b does not confer a right to appeal to the person who has failed to succeed, while invoking the provisions of the said section. Once the Section 10b is successfully invoked, Register of Land automatically stands altered, and therefore the legislature in subsection 2 of said section has provided that the provisions of sections 8 and 9 shall mutatis mutandis apply to the hearing and decision of any matter raised under subsection 1 of the said section, as if those were raised under the aforesaid sections, As a result, the altered register of land would be required to be republished under Section 10, opening the gate for objections and appeals. But if Section 10b is not successfully invoked, that is, if by reason of rejection of the application, register of land is not altered, then there is no scope of republication thereof, and as a result there shall be no further objection or appeals available thereto. Unsuccessful person in such circumstances may take recourse to revisions under Section 35 if by that time notification under Section 26A of the Act or subsection 1 of Section 4 has not been published. Revisional authority is required to hear and depose of the revision application and could not remand the matter to the appellate authority. Full stop.